A shocking courtroom outburst. This former teacher is given jail time after stalking her ex-boyfriend. Courtroom video per WKYC TV. We have the body cam video of when she was first arrested after allegedly going to her ex's work more than 30 times in 19 days.
Hannah Freeman.
Hannah Freeman? Are you supposed to be up here? Mm-hmm. You are? Were you in his vehicle earlier?
Mm-hmm. What went down in court leading up to that shocking reaction? We're on the case, presented by Law&Crime. I'm Chris Stewart. Well, what was supposed to be a hearing to put an end to a case involving a former teacher in Ohio did not go as planned. This is Hannah Freeman in court yesterday near Cleveland per WKYC. She pleaded guilty to stalking her ex-boyfriend, who was also a teacher, and she thought she was going to just receive probation, but then she shrieked when she learned that was not the case. So let's get you caught up on how we got to those fireworks in the courtroom this week. This is Freeman's mugshot from November of last year. She worked as a 4th grade teacher and she was suspended after her arrest. Police in Westlake, Ohio say this is her vehicle driving into the parking lot of the middle school where her then ex-boyfriend worked. This is surveillance video that shows Freeman's car, that red vehicle that passes by outside her ex's school. Police say she visited the school 33 times in just 19 days. And this was months after her ex said the two of them had broken up. Police say she went to the school, she sat in her car, and just waited in the parking lot.
Westlake Police, how can we help you? Westlake Police, how can we help you? Hello?
My ex-girlfriend continues to stalk me and park her car next to wherever I am and follow me home every night.
How long has it been happening?
Probably a month now.
Have you ever contacted police about it?
No.
Okay, where are you at?
So, as I just called you, she got back in her car and stormed off.
That was a 911 call that her boyfriend made. And then on November 7th, Freeman goes to the school. Her boyfriend calls 911 again. And this time, officers arrive and confront her in the parking lot.
Hannah Freeman.
Hannah Freeman? Are you supposed to be up here?
Mm-hmm.
You are? Mm-hmm. Were you in his vehicle earlier?
Mm-hmm.
No?
Well, we went to get dinner together, but...
You guys, where'd you guys go get dinner at?
King's.
King's?
King's, yeah.
Raising Cane's? Which one?
North Olmsted.
North Olmsted? Okay. Well, we got a complaint from him that you were in his vehicle tonight and you're harassing him and stalking him.
I mean, I don't know what to tell you.
Okay. Did you take some items from him last night?
Police also went inside the school and talked to her ex, who said not only was she stalking him, but she broke into his car and did much more.
Did you invite her here?
No.
Are you sure?
No. Yeah, she
Are you sure you didn't invite her here?
Yes, I never invited
Okay.
her to anything.
Because she said that you invited her here.
Yeah, I know. She probably would say that. She actually yesterday followed me to my apartment, stole stuff out of my car.
Yeah.
Medications that I need, my car keys, which I was finally able to get back from her, a laptop, and my wallet. And she has run up a bunch of charges on one of my credit cards now.
Oh, she did?
Yeah, and then she, because I did date her back in April, we probably ended it. She kind of knew passwords to like my accounts and stuff.
Where did
she's been messing with my accounts.
Where did she rack up the charges at?
That was all from Amazon.
Oh.
Police arrested Freeman in the school parking lot.
Is your phone in the car?
I am. I'm putting it down.
Step over here.
I'm putting it down.
Do me a favor, turn around, put your hands behind your back. You don't got anything on you that's going to stick, poke me, anything like that? Put your hands together like you're praying. the keys to the car?
I don't know. I can't find them.
You have a phone number? Ma'am, what's your name?
Hannah Freeman.
All right, Miss Freeman. Just so you know, you have the right to remain silent. Anything you say can and will be used against you in a court. You have the right to consult an attorney and have an attorney present during any questioning. If you cannot afford an attorney, one can be provided to you before questioning at no cost. Do you understand these rights?
Yes, can I call my attorney now?
Once we get back. I don't have any questions for you. Step back over here to my car.
Can I please call my parents?
Just step over here to my car.
Freeman was arrested and charged with menacing by stalking, burglary, 2 counts of aggravated theft, identity fraud, and theft of drugs for taking her ex's medications. That was November. Let's talk about what happened in the courtroom this week. Freeman was in court for her sentencing. She agreed to a plea deal last month. She pleaded guilty to lesser misdemeanor charges, and her attorney said that he and prosecutors had made a deal that would spare her jail time. Here's what Freeman said in court per WKYC.
I regret the incident. I definitely acted out of emotion, and I regret that decision that I made that night, and I will take steps necessary to move on from this incident, and you will not see me back here again.
But here's where things get hairy for Freeman and her defense attorney. The judge called the case a, quote, bizarro breakup between 2 professionals. He then gave Freeman a sentence. It included 90 days probation, house arrest, and wearing a GPS monitoring device, along with mental health counseling. Then, per WKYC, the big one that blew this hearing up.
You will serve the first 7 days of this term of probation in our county jail. You are ordered remanded.
At this point, her attorney tries to withdraw her plea and go to trial just to keep her out of jail. He says that the defense and prosecution had agreed on a sentence, but the judge said they hadn't consulted with him. He said that the defense attorney didn't make an effort to meet with him over the past several months to see how he would sentence this case. And once the judge said the hearing was over, this happened.
Your bad practice is not my problem. I don't think it's my order remanded. We're done.
Freeman was then walked out of the courtroom to begin serving her 7-day sentence in jail, and you could hear her crying and shrieking as she left. Joining us now to talk about this is Diane Menashe, criminal defense attorney. Thank you for joining us. What happened in this court hearing? How did it go this way?
Well, I mean, I think he didn't talk to the judge, right? Like, we watched the video, and it was an agreed plea agreement, and that was between him and the state of Ohio. And we all know that as defense attorneys, we have to tell our clients, like, well, this is the plea deal. The judge is the one that ultimately decides, and here are the maximum possible penalties. And as I listened to the whole video, I mean, it was really clear that the defense attorney, didn't do what all of us do, which is before we enter into that courtroom, we make sure that we sit down with the judge and we know as much as we can what's about to happen and unfold so that we can prepare our client. And he just didn't do it. He took it for granted that the judge was going to follow the jointly recommended sentence, and he didn't. So yeah, it was a real fumble, to say the least.
What is the expectation that a judge and a criminal defense attorney have in these situations when a plea deal works out?
Well, I think the expectation is, as we all know, not all judges are the same. Some are really approachable, will be very transparent about whether they're going to follow the joint rec or not. Some will say, well, I understand the joint rec, but I can't agree to follow it. But either way, making sure you have that conversation with the judge is so important, so that you can then go out into the courtroom or into the holding tank or wherever your client is and tell your client, like, hey, this is what we talked about with the judge, and be prepared for it. But I think otherwise, I mean, the language in every plea and sentencing is that ultimately the one and the only one that decides the sentence is the judge. So the clients have to understand and be made to understand that aside from the jointly recommended sentence, it's the judge who decides in the end.
And because I look at that, and it's like, if you're a certified defense attorney, like, how do you not know that? And I like, that's kind of like, you're the defense attorney, where I think of, because this hearing, it seemed like if you watch the full thing, like from the beginning, the judge, like things were icy, a very serious case, but like things just seemed to be icy between the defense attorney and the judge. What did you take of was that tone something different than what typically you would expect in this type of hearing?
Well, 1,000%. And it just from the beginning of the hearing, I was like, like you could tell that there was friction in the room between the defense attorney and the judge, which is never to the benefit of the client. But then it got, escalating worse when he was essentially, accusing the judge of not being available. And the judge really threw it right back at him, said, this isn't a question of my availability. It's a question of you not doing your job and coming to me and talking to me about this. It is, as we all know the expression, like a rookie move. This was some rookie lawyering.
Because she was arrested in November of last year. We're in July. They reached this plea agreement last month. So, I mean, how long of a meeting would this typically have been with the judge to go in and talk to him about this sentencing if he had done it?
I think twice, really, there should have been meetings with the judge. Once on the day when she took the plea, before taking the plea, really shop talking with the judge and saying, this is our expectation. And then also before the sentencing. But there wasn't even any effort on the part of the defense attorney to proactively address the really bad facts of the case. And as we all know, this was a case where she was indicted with 5 felonies and she ended up pleading to 3 misdemeanors. So she, in the judge's eyes and in my eyes, an experienced criminal defense attorney, I would tell a client that given that you're not getting a felony, you should perhaps prepare for some local jail time. I mean, it's just kind of 101, right? Like the optics were, she's getting a really great deal here. I mean, she didn't have to take a felony offense. She's not looking at prison time. And so doing local time as part of a probation sanction is not surprising at all.
Why would the prosecution, because they seem to have a lot of evidence against her. She was stalking her ex-boyfriend. She visited his school, I think it was 19 times in 33, or excuse me, I had it the other way around. It's worse. Yes. 33 times in 19 days. Surveillance video. Why not prosecute this case? Because, as much as you could say it was, in the judge's words, a bizarro breakup, but at the same time, like stalking is something you never know if it could go to a level that would be something far more serious than what it was.
Yeah, I think that we can't presume it was because of great defense lawyering. I honestly think in this case it was because the victim really wanted to resolve the case without going to trial. And certainly everything I read and what the prosecutor said on the video was that the victim, obviously under Marcy's law, authorized and approved the resolution. And I think that was the driver in this case. We have that in a lot of these cases where the victims just, they want a sanction. They want some guardrails put on this person. They want the behavior to stop, but they don't want a trial. They don't need someone to go to prison, and in this case, at one point they did have a relationship. So I think it was victim driven, certainly from what I've read and what it appears on the video.
Why is it on the defense if this plea deal is going to be made? Why is it on the defense to meet with the judge as opposed to, and I don't know if the prosecution met with the judge, but more having the district attorney or ADA, whoever it is, to meet with the judge to talk about the plea deal?
Well, we would all meet with the judge, because you're not allowed necessarily just to go in and kind of just like, hey, judge, I'm here. But I think we would all go in. This is just standard protocol. To say, hey, judge, we have a resolution. This is what our proposal is. What are your thoughts? And then on the day of sentencing, saying, hey, judge, just checking back, especially after what we know in this case is the PSI, as referred to by the judge, which he said that there was some really bad facts in it. Well, the defense attorney has an opportunity to review the PSI. And as soon as we review the PSI and we see that there are some things in there that are really problematic, that's another reason to approach the judge before the sentencing to say, hey, judge, read that PSI. I know some of these things are troubling, but let me give you some color and context before we go into that courtroom. I mean, these are the things that you've got to be proactively doing as an advocate for your client. And it appears from the video that this defense attorney did not do those things.
And when things got hairy, and you have this moment where the judge says she's going to jail, and then suddenly the defense attorney's like, wait a second, we had a deal. And then he tries to withdraw the plea deal, and the judge didn't allow that. I mean, take us inside how that part of this, what really ended up being kind of a mess near the end, how it all ended up going.
Yeah, it was like I didn't even understand how he jumped to we're withdrawing the plea, and then he said it's not knowing and voluntary, which, by the way, at the plea hearing, the judge had gone through the full colloquy with her about understanding her rights, the maximum possible penalties. So it was knowing, intelligent, and voluntary. And I watched that plea hearing transcript or the video, and he literally said to her, do you understand that in the end, I'm the one that imposes the sentence, as long as it's within the maximum possible penalties. So for the defense attorney to say, I'm going to withdraw the plea, it wasn't knowing, intelligent, voluntary, the judge rightly said, well, the only problem here is that you didn't prepare your client and approach me and ask me if I was going to follow it or not. Yeah, I mean, it just kind of goes back to that rookie, just real gap in service here to the client.
And on her end, she makes a statement in court, and it came off to me, it was scripted. She was looking down at notes. She kind of had like the body language, at least to me, and I'm not a body language expert, but just in the peanut gallery, I do that for a living. And it just didn't come off as authentic. It kind of was like, hey, judge, I'm not going to be here again. Like almost like checking the box and taking him for granted. How did you read that part of it?
I read it exactly as that. And, in preparation for today, when I watched it, it was another moment where I grimaced because that's again a failure of her attorney. She's looking down like it's something that's written. And what she did say was not complicated and certainly should have been memorized. But further to your point, it wasn't authentic. It didn't have any emotion behind it. It was formulaic, didn't it? It felt like to me, and I think you're saying it too, that she thought it was a wired deal and there were going to be no problems here. Instead of really talking about like how she's a different person than she was when she got arrested, the changes that she's made, what she intends to do in the future to continue to prove that she's worthy of this plea deal. And I just have to say, like, I don't blame her as much as I blame the defense attorney for that. You've got to prep your clients for this moment. Like that is the moment when the client first speaks. Certainly in this case, that was the first time that she had been heard other than saying, guilty, not guilty.
Yeah, because as I watched it was like 13 minutes was, the hearing for the most part. And so much changed over, it felt like a long time. And it's like how it's going to end. And then you feel like the iciness between the judge and the defense attorney. And then she gets up and then you're almost just like hand over your eyes, like this is not going well. For her as a client, can she sue or do something just because she did not get the type of counsel maybe that she was expecting to get?
Well, she can't, because in the end, the judge did the colloquy at her plea hearing, and she answered all of the questions that needed to be answered. You would understand the maximum possible penalties. The state set forth the facts of the case, and she agreed to those. So there isn't, any kind of lawsuit, if you will. I mean, certainly her reaction showed that she never thought going to local jail was a possibility, and his behavior showed the same. But, I just think that this is just an unfortunate case of, she just wasn't prepared. And that was to no real fault of her own. I really don't, this is not a client problem. This is an attorney problem.
Because you hear after the statement, it's kind of like a hot mic as it's over. And like the attorney is still talking about the judge. And I just felt like that's something too that, as far as is there some sort of issue he could have as far as, I'm not saying he's going to be disbarred, but something along the lines of that? Like, is there a punishment that could come his way because of how all this went?
Well, I think the punishment will just be in reputational harm, right? And I think that if anyone ever hires him and they have a case in that courtroom, they should get a different attorney, because that judge and him do not, I think that was a moment in time that the judge will not forget. And I'm not trying to say that the judge would hold that against, future individuals, because judges are, trained to be literally objective and inherently, unbiased. But I just think that that's a moment that no one will forget that watched it or that was there in the courtroom. And so I just think there's some real reputational harm that will come his way. And just again, like that's just not, as a defense attorney, I was watching his behavior. That's not how we defense attorneys should be behaving. That's not how we should be interacting. That's not how we should be talking to judges. And hot mic'd or not, You just don't say that kind of thing. I mean, it was too much.
And what's typically your relationship or any defense attorney's relationship? Because I know that there's going to be cases that don't go your way, but what is the typical relationship that a defense attorney has with the judge?
I think those of us that really like practice in the space realize that, relationships are earned and as are reputations. And, you have the conversations with the judge, you do the homework, you prep your clients. You also are aware of the reality, like you've just said, that not every judge will follow a jointly agreed sentence. But you certainly want to prepare your client for every scenario. And in this case, again, I can't say it enough. I mean, she clearly wasn't prepared. That's just on her attorney. But I think having a good relationship with the judge, and by that I mean professional, it's just like the same thing about having professional relationships with the prosecutors. Those are really important. They're just critical, right? You got to get along with people, and you've got to be diligent and doing your job and a good advocate, and that will come with a good reputation. And then of course people will respect you, and ultimately that will lead to better results for your client.
If he had followed all the rules that you're supposed to and just the procedures typically that goes into it, I mean, how rare is it for a judge to not follow the sentencing that the prosecution and the defense have agreed to?
It's I would say more often than not, judges will follow jointly recommended sentences. But I do have to say, moments in a sentencing can change a judge from wanting to follow the jointly recommended sentence to deviating. And it would not surprise me is if in the judge's head he heard her statement and had the same reaction to it that you and I did, and then deviated and gave her the weak local. I really felt like her statement was dismissive. I don't think it was, it rose to the occasion of the moment. Like that was her time to really talk to the judge about why she deserved the opportunity for no incarceration and how she's different and why she will not, do this behavior again. And instead she just dismissively was like, "You'll never see me again."
Yeah, and it's I get where it's got to be nerve-wracking. I mean, I've never been in that situation where facing a judge, you want to make sure you say the right things, I'm sure, but then at the same time, it's like she wasn't quoting Shakespeare. Like it was a very straightforward kind of speech that she needed to look down for as if someone else wrote it, or at least that's just how I took it in.
And it's how it came across. It's how it came.
And if you're a judge, and this judge, he seemed very seasoned. I mean, he clearly knew what his expectations were. It just didn't seem like the type of person you would want to fall flat on when it comes to that. Even with all, going back to just the case and the facts itself, and what she was originally charged with, these 5 felonies, all the evidence it seems that they had, how long it went on for, even with how things went, how fair is this sentence for her? Is it a fair sentence of having to do 7 days, 3 months probation, mental health counseling, and all of that? But I feel like with 5 felonies, it could have been a lot worse.
I feel like this, again, I think to no credit to the defense attorney, this is a great deal. She isn't convicted of a felony offense. She has 3 misdemeanors on her record, which actually, the issue of whether those are expungible or not will be down the road. But she's on probation, she's got some parameters, and she does 7 days of local incarceration. I mean, she could have gone to prison on 5 felony counts that could have been run consecutively. And you've said it best, from everything I've read, the evidence here was overwhelming. Surveillance, she was literally found at the scene in her car. I mean, this was not a whodunit case. So 7 days in jail, all things considered, with 18 months of probation is an incredible result for her. And certainly I will tell you, if I was her attorney, that would have been my focus. That would have been my focus.
Well, I'm sure she has 7 days, in jail, and then hopefully we'll be on her way and won't, in her words, be in front of a judge
ever again.
Never again. Criminal defense attorney, thank you as always for joining us on Law&Crime. We appreciate it.
Thanks for having me.
That will do it for On the Case, presented by Law&Crime. Subscribe to us on YouTube and Spotify. I'm Chris Stewart. We'll see you next time.